correct?
Yes, sir.
Agent, you've been to school to learn how to testify, correct?
Yes, sir.
And in your teaching or schooling, you learned to use the phrase "is consistent with," correct?
I don't remember being told that particular phrase.
Diagrams, remember the baseball-looking images, baseball diamond-looking images?
Yes, sir.
Shows an arc, correct?
Yes, sir.
And I think that you testified before that the actual footprint on the ground may or might be different.
That's definitely going to be different from that depiction we used.
Okay. And some of the things that can affect a signal coming back and forth is a building or a large structure.
Yes, sir. Whether a phone is inside or outside a building? Yes, sir. They can have some effect on how long the time it is.
Talked about that it doesn't necessarily pick up the closest tower, but the one with the strongest signal, correct?
Yes, sir. It's the strongest signal with the least.
Is that yes?
Yes, sir.
Thank you. And is it true or false that a signal can bounce off a building and still be received by the cell phone?
Yes, sir. The signal can bounce off a building and be received. The cell signal is not a perfect piece of pie shape. It's an undulating line. Does that sound familiar? Yes, sir. I can narrow it down to those arcs, but no, I can never say the phone was at 123 Smith Street.
Hypotheticals about 6609 Warm Breeze. That was Ms. Harris' house, I believe.
Yes, sir. I just want to make sure I made the research address. Yes, sir.
And the question generally was, is that consistent with XYZ, correct?
Yes, sir.
And then you followed up with, obviously, but did you previously say, obviously I can't state that's what occurred?
No, sir. It was hypothetical. That was one that fit what the cell phone record showed. I moved to the phone, but I can't say, did it take a left turn at this street or anything like that. You can't do that.
But you can't say that's what occurred, though, correct?
No, sir.
Okay, because in your last testimony you said, yes, are they consistent with that? Yes, they are. And then you followed up yourself, but I can't say that's what occurred.
Really, Coach?
Yes.
Hypothetical about the Warm Breeze house yesterday. On Warm Breeze, would it be accurate to say that obviously you cannot state that's what occurred?
Yes, sir.
Defense counsel just questioned you on, does that change what you told the jury about what happened with the defendant's phone on January 30th?
No, sir.
Anything about what he asked change your analysis about the defendant's device location on March 15th?
No, sir.
Anything change your analysis on March 19th?
No, sir.
March 19th, we're talking about the device being at 5,000 Old Shepherd.
Yes, sir.
4,500 Pear Ridge.
Yes, sir.
And Diamond and Gold Exchange.
Yes, sir. As I stated, just in the area of those locations, I can't say there, but in unit towers that have covered areas that include those locations.
Same question. Any of those questions for defense counsel change what you told this jury yesterday regarding your analysis on March 20th?
No, sir.
Pass the witness.
Mr. Watson?
Your Honor, I have no further questions of this witness.
Okay, thank you. May this witness be released?
Subject to recall, Your Honor.
All right, thank you. So you are released subject to recall. Thank you so much.
Yes, Your Honor. Thank you.
You're welcome. And state you may call your next witness.
Thank you, Judge. We'll call Dr. Jeffrey Bernard.
All right, good morning. You so solemnly swear and affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. Mr. Fitzmartin, you may proceed.
Thank you, Judge. Good morning, Dr. Bernard. Can you please state your name and introduce yourself to the jury?
Jeffrey Barnard, B-A-R-N-A-R-D.
And how are you employed?
I'm the Chief Medical Examiner for Dallas County, and I'm the Director of the Southwestern Institute of Forensic Sciences, which is the Medical Examiner's Office and the Dallas County Criminal Investigation Laboratory.
How long have you been at the Dallas County Medical Examiner's Office?
I've been there since 1987,
And how long have you been the director there?
since 1991.
And tell me your training and background that allows you to hold that position.
Yes, sir. I attended Texas A&M University and received a Bachelor of Science in Medicine degree. I attended Texas A&M College of Medicine, received my MD degree. I served a one-year general surgery internship at Scott and White Hospital in Temple, Texas. I served a 4-year combined anatomic and clinical pathology residency at Scott and White Hospital in Temple. I served a 1-year fellowship in forensic pathology at the Medical Examiner's Office in Suffolk County, which is in New York. I'm board certified in anatomic pathology, clinical pathology, and forensic pathology. During my residency and fellowship, I worked on a part-time basis as an emergency room physician. I'm a diplomat for the National Board of Medical Examiners, a professor of pathology at UT Southwestern, and I'm the current chairman of the Texas Forensic Science Commission.
Thank you, Doctor. Tell me, the Medical Examiner's Office, I think, and we kind of interchange it with an acronym of SWIFTs. Is that right?
Yes, sir, that's the whole institute.
Okay, and what does SWIFT stand for?
Southwestern Institute of Forensic Sciences.
And so you'll forgive me if I just refer to it as SWIFT from time to time, because that's kind of what we do often around here. Is that a training facility?
It is.
All right, tell us how that works there at the Medical Examiner's Office.
Well, similar to what I explained what I did in New York, there is a 1-year training program in forensic pathology at the Medical Examiner's Office, and it's in conjunction with UT Southwestern Medical School.
So from time to time, you'll have fellows there that are learning from you and the other medical examiners that you have on staff there at SWIFT.
Yes, generally every year.
Okay. And are you familiar with a Dr. Danielson?
I am.
And was he a fellow there at one point in time learning from you?
Yes.
And actually, have you hired him back and he's going to be coming back to work with you all later in the year?
Yes, he should be here next month.
All right. The week that I want to talk to you about, back in March of 2018, and the autopsy of Lou T. Harris, were you the supervising doctor for Dr. Danielson at that time?
Yes.
And were you part of the autopsy and supervising Dr. Danielson of Lou T. Harris?
Yes.
Now, I want to ask you about your experience with the act of smothering. Have you had an occasion prior to Ms. Harris to investigate offenses where smothering was the allegation?
Well, where smothering became the cause of death, yes.
Okay, tell us about that.
Yes. I've had a couple of child smothering cases, one of which the individual confessed that he had put a bag over a child's face until the child was smothered to death. The other was an autopsy that I performed of an infant who was face down in a pillow and then had bruising over the back of the head, really consistent with fingerprint marks, bruises from fingerprints. And based on the scene investigation and those findings, I ruled that as a smothering. And an adult case where the victim had Alzheimer's disease. The husband wrote a note stating that he smothered her and then he overdosed himself. So 3 cases for sure.
Now, based on, is that something that's maybe unique to a medical examiner to actually have the known, you know that there's a smothering happened and you actually get to do the autopsy of that individual?
Well, it is unique to a medical examiner's office because those cases, that sort of certification and determination of the cause of death would be unique to medical examiners. And just, coroners in other states may make the ruling, but a pathologist has to do the autopsy and generate the findings.
We've already seen State's Exhibit number 223. And we went through that pretty in depth with Dr. Danielson, and I don't want to go through it line by line here again, but ultimately you agreed with the findings of Dr. Danielson.
Yes.
And your signature, it follows him directly behind, is that right?
That's correct, and that indicates that I was a supervising medical examiner.
Some of the findings that, or the things that indicate to you all about smothering, as we look at State's Exhibit number 208, and in drawing upon your experience of the other adult autopsy that you performed that was a smothering case, were there consistencies between what you observed in that case and what you observed here in Ms. Harris's case?
Yes.
Okay, can you kind of walk us through some of those as you see here in State's Exhibit number 208?
You have a significant number of petechiae, which are the little pinpoint hemorrhages that you can see on the face, more prominent on the left side, but they are present on the right side. You can see a few of them, but they're more dramatic on the left side. But those are little pinpoint hemorrhages where the little blood vessels have ruptured.
Now, is it possible that she's found on her left side? You're familiar with that?
Yes.
And the amount, and sometimes you would think that, well, maybe there might be some sort of pooling that might increase the amount of petechia or anything like that when it comes to the left side of the body because of how she was found. Is that?
Well, yes. I mean, they, I think, are more enhanced being on the left side because of gravitational effect.
But in a situation like this, where we have on her right side, we also see the petechia on her chest, those types of signs. Those aren't going to be anything to do with the gravitational pull of the earth or anything like that.
Correct. That's my opinion. They have nothing to do with it.
Okay. Now, someone who's on their left side, a smothering type case like this, can it cause blood to pool maybe in the mouth and the nose area?
Well, yeah, it's not. That wouldn't be necessarily unique to smothering. smothering, you have mucus and saliva that get trapped, and so, yes, you can have that in your airway or your nasal passageway.
In fact, anytime, like you said, anytime someone passes away, they might, blood might come out, however it might, had the death occur.
Blood or other liquids or whatever.
Okay. Now, if someone was left on their left side, let's say hypothetically they're smothered with a pillow, and then left on their left side and found hours later, what would you expect that blood and that discharge to look like if it had occurred either at the time of the smothering or shortly thereafter in the process of waiting to be found?
Well, you would expect if you're talking about the gravitational and positional, that you'd expect it if they're on their left side, it would run out by gravity to the left side.
And then if it's hours later and it's not a flowing situation, like maybe a head wound or something like that, but if it's hours later and it's just a trickle out, would you expect that to be dry?
Well, if it occurred hours before, it very well may be.
Okay. We saw this picture, State's Exhibit number 202 of Miss Harris. And in this picture, what direction is the discharge flowing off of Miss Harris?
It's going to the right of her face.
So it is not consistent with it happening and then drawing like the gravity would to the left side if she's laying down on her left side.
That would be correct.
And if someone was to take and you're familiar with the evidence was collected in this case, is that right?
Some of it, yes.
Okay. The evidence that pertains to your findings.
Yes.
And you know that this pillow was found in her home with this mark, with this stain on it.
Yes.
All right. Now, if someone was to take this and put it over her face, and that discharge, obviously, then if it's not here, it hasn't started. If it's not on this pillow.
Correct.
Okay. And if she's left down on the ground, if it happens to her down on the ground, and she's on her left side when this pillow is then removed, or she's moved to her left side, and she stays there for 2 or 3 hours, okay, maybe even more, maybe 5 or 6 hours before this photograph is taken, then obviously that discharge is not happening because it's not going down through her left side.
I would agree with that.
Okay. So when the medical examiner's investigator goes out to the scene, well, let me just to finish up with this pillow, then you wouldn't have that discharge on this pillow. Is that right?
Right.
Okay. If you look on that photo there, do you see a blue, shiny substance behind her on her left side?
Yes, it's a body bag.
It's a body bag. So at that point in time when this photograph is taken, Miss Harris has now been moved to at least a position that's on top of a body bag.
Yes.
Okay. And so there's been some manipulation of Miss Harris's body at the point in time when this photograph is taken that could, as we look at this, look closer to the discharge here. Do you see it as being shiny?
Well, right by the nose, it's shiny.
Okay. So it's not dried.
No, I think it's liquid.
Okay. And so at the time that this body is, this photograph is taken, it's been moved and manipulated onto a body bag, and the discharge is flowing from to the right side.
Yes.
Now, I want to talk to you about another case, the case involving Mary Brooks. Are you familiar with that case?
Yes, sir.
Permission to approach? I'm going to show you what's marked the State's Exhibits 292, 293, and 321. Are you familiar with these records? Is 292 your original in abstention report for Mary Sue Brooks?
Yes.
And is 293 a redacted form? form of it?
Yes.
And is 321 the cause of death report?
Yes.
Judge, at this time we'll offer 292 for record purposes, 293 and 321 for all purposes.
So State's Exhibit 292 will be entered for record purposes only, and State's Exhibits 293 and 321 will be admitted for all purposes.
At the time of Miss Brooks's death, it was classified as a natural death.
Originally, yes.
Sometime later, were you asked to take a look at the what evidence was available at the time, and not only at the scene, but then of the investigation into the death of Mary Brooks?
Yes, sir.
Based on the information that you were given, based on the totality of the circumstances, did you change the natural death finding to something else?
Yes, I did.
And what are the possible things that you could change the finding to? What are the classifications that you could change?
Well, that talks about the manner of death. So you have natural and you have unnatural. And within unnatural, you've got suicide, homicide, accident, where you could rule it undetermined.
And in this case, based on the information that you were given, what did you change this to?
Well, I changed the manner to homicide, and I changed the cause of death to homicidal violence, including smothering.
Some of the things that you looked at in changing this, we had some photos. Station number 246, 247, 248, 249, 250, 251, and 252. Were these all presented to you in your investigation of this case?
I reviewed all of that. I reviewed the body cam video.
There's Officer Harris that went out, and we saw portions of his body cam video where he does an examination of Mrs. Brooks's body. And you watched that.
Yes, I did.
Did you also, were you made aware of phone evidence connecting to a Billy Chemirmir?
Yes.
And that Mr.
Well, an individual that eventually the name became known.
A suspect. And were you aware in your determination about an attack that was made on Mary Bartell the morning of March 19th?
Yes.
And were you made aware of the circumstances which she told happened to her, as far as a pillow being put over her face and someone stealing her jewelry?
Yes.
So by the time you're looking at Mary Brooks's case, you've already heard about Mary Bartell, and you know and are familiar with Lou Harris's case, where there's also a smothering case with jewelry being removed from her body and from her home.
Yes.
When it came specifically to Mary Brooks, you noted in your view of the information that you were given, that there are some signs on her body of potential injuries.
Yeah, I saw what looked to me in viewing the video cam that there may have been some superficial blunt force injuries. Not dramatic, but just superficial things like a bruise or a scrape, but not substantial injuries.
And that's part of what you do in your determination. You're going to put that in a report. If you see it, you're going to report on it.
If I see it, then I will make note of that.
Okay. Now, you don't know if, for example, on this picture here, does it look like she might have some bruising on her right hand?
It does.
Okay. Do you know or can you tell, based on this picture and what you have in front of you, when that bruising might have happened or anything of that nature?
No.
But you do know it.
Right.
In this case, though, were you given information that the day before this, she was seen at a Walmart buying items?
Well, I knew she was at a Walmart. I don't know what she did or didn't purchase.
Okay. You were more interested in the timing of where she was at.
Right.
Were you also made aware that a car matching the description of the same car of the individual who attacked Mary Bartell, who's a suspect in Lou Harris, was also seen at the same time at that Walmart?
Yes.
Were you made aware on the phone that the phone of this same individual was seen not only at the location of Mary Bartell, seen at the other locations where we can identify where a certain individual was by video, that phone was also at the Walmart and then followed and went to her home?
Yes.
Were you made aware that the next day after she is seen at Walmart, that on the 31st of March, on a app called Offer Up, that a unique ring identified by Mary Brooks was being sold by this exact same individual?
That there was an online site. I don't know that I recall the name of it, but I do recall that.
And if I said the 31st of March, I meant the 31st of January. Okay, the day after after this deal.
Sorry.
Okay. Were you also made aware that on January 30th, that there was a sale by this same individual at the Diamond and Gold Exchange, in the amount of $2,150, 14 karat gold and diamonds, and then another sale on January 31st for $3,050 for 14 karat, 18 karat, and for diamonds? You were made aware of the sale of items at a local jewelry store.
The 31st, I'm aware of that. I don't recall the 30th.
Okay. But close in proximity to the time that Mary Brooks is attacked or is found dead, that same time frame, there's a sale being made by a certain individual, Billy Chemirmir.
Yes, the online was, I believe, listed as the 31st, and then the jewelry exchange I had listed as the 31st. If that's incorrect, I don't know.
That's fine. So based on all this information, are these the things that caused you, in your professional expert opinion as the chief medical examiner for Dallas County, to change this first finding of natural to homicide and by the cause of death of homicidal violence?
Yes, taking into account all the information that compelled me to change the ruling on this case.
And is that what we see? State's Exhibit number 321, your signature changing Mary Sue Brooks, an 87-year-old white female, to homicide.
Yes.
I'll pass it.
Mr. Warren?
Thank you, Good morning, Dr. Howard.
Morning. Thank you.
I have a few questions for you. My name is Colby Warren. You had opportunity to speak before, is that right?
Yes, sir.
All right, good to see you again. And the jury is heard, but I mean, you're the head boss down there, so let's hear it from you. There's lots of different reasons why the TK may be present on a person. Is that correct?
Well, the TKI can be formed for magnitude of this, but there are other things that can cause petechiae.
Like what, for instance?
Well, you can have people that have congestive heart failure. You can have people who are found completely in a certain position that when the blood is still liquid, can in fact, because of gravitation, cause that. People can get they can get from nausea and vomiting if there's a lot of intrathoracic pressure. Although I've only seen that in eyes. I've not seen it at all in the chest or neck or anything like that. But there's several things can do it.
Right, and I know you're trying to relate it back to the autopsies, and we'll get there. But I'm just saying in general, like it's the popping of the capillaries of blood vessels results from strain. Is that correct? I'm sorry, strain or strenuous activity.
Well, it can be.
And that could, could be heavy weightlifting, sustained pulling or pressing or pushing of something. I mean, those are the kind of things that can cause petechiae, correct?
Well, if you increase your pressure enough, you certainly could cause some potential hemorrhage.
And you stated earlier, like congestive heart failure. So with congestive heart failure, does that mean that the heart is not pumping as effectively as it should?
Well, if they die of cardiac death, then the answer would be yes to that. But petechiae don't necessarily form because of the congestive failure. It's just I've seen it in heart failure deaths.
Right. And you've also seen petechiae on the heart before too. Is that true, Doctor?
Yeah, that's not a terribly uncommon finding. It's on the surface of the heart.
Because the heart's a muscle, correct?
Yeah, it really has to do more with the blood vessels that have ruptured, less the fact that it's a muscle, but it is a muscle.
Right, and as you say, it has blood vessels contained within itself as well, also. Is that right?
Yes, that's correct.
And the more it strains, then obviously petechiae is possible to be formed and shown. Is that right?
Well, that's a possibility.
Now, Mr. Fitzmartin earlier was asking you about your findings, and we'll break them down. Regarding Ms. Harris as well as Ms. Brooks. But he had asked you to give your experience on smothering, and you said you had a couple initially. The first couple, I believe you said one was with a child that was someone admitted to placing a bag over a child. Is that correct?
Yes, sir.
Okay. The second one was a child or someone's face or being pushed into a pillow.
Yes.
Okay. And then the third, you said it was confession regarding an older person, married couple, husband.
Put a pillow over her face.
They euthanasia of his wife. Is that
yes.
correct? Okay. And then he took his own life.
Well, he overdosed. I'm not sure that he died right away, but
yes, sir.
That was the intent.
And in those situations, it was. Did you still do autopsies on those?
Yes.
Okay. And did what you find in your autopsy that was consistent with what you were told and information you received by way of confession? Is that right?
Well, in the children, there were no petechiae. In the elderly lady, there were a large number of petechiae, very similar to this.
Okay. Regarding that, and you would agree with me, Dr. Bernard, that in and of itself, smothering without additional information, to make a determination of smothering without additional information is pretty difficult for a medical examiner. Do you agree with that statement?
That would be difficult to do. I did it only in one case, but I found something at autopsy that was compelling. But in general, it would be without investigative information or some other finding at autopsy. It would be difficult to make the call.
And even in the situation with Ms. Harris's case, which we're here for, may I approach her? That we're talking about of the scene of how Ms. Harris was found, is that correct?
Yes, sir.
Okay. And Mr. Fitzmartin was asking you in regards to how she was found and located. And with that initial information that was received, you still needed the additional information which Mr. Fitzmartin laid out for you in regards to the things that you observed after the fact to be comfortable making that determination of a smother. Is that right?
I have to kind of say yes and no to that. Yes, in that the totality of the information is important in making your ruling. No, from the standpoint that the petechiae that were on with her positioning and then the contusion in her neck muscle would have raised a concern. But would we have called it right away without anything else? Well, that's kind of unanswerable because we do have other information.
So, Doctor, on states 223, which is Ms. Harris's autopsy, on page 2, as we look at so when you talk about the interior strap muscles of the neck, what is that exactly?
Yeah, that'd be the musculature in the front of the neck.
Okay. And there was no evidence of hemorrhaging there, is that right?
That's true, yes.
Okay.
But there is a hemorrhage in there. Just, I want to make clear, there's a hemorrhage. It wasn't the anterior strap musculature.
Doctor, how long does petechia last? Like, how long will it be evident or apparent on a person?
Well, once the little blood vessels rupture, then they will be there. I really couldn't tell you, how long it takes for post-mortem decomposition. They're there at the time that they're there because it isn't the fact that it's in the blood vessel, it's because it's outside the blood vessel. So they really should be there.
Right. And I'm not speaking of post-mortem, I'm saying in general. Like, say for instance, I was lifting weights and I'm trying to throw some heavy weight and I strain, I get petechia out, for instance, and that's possible, correct?
Yes,
Okay.
I would say, well, I haven't personally experienced it, and I haven't seen anybody's got it from lifting weights. I've seen it from people vomiting. But I'll just take that you're hypothetical that you could get that. And so you're asking me how long it would take for that to go away?
Yes, sir.
Well, that would be kind of in the same time period that it takes with bruising in a healing fashion. So, that depends on how much it is. So the more hemorrhage, the longer it takes. But it would be at least several days, I would expect.
Okay. And then, and let's say that within that week after that I had petechia, let's say that I pass away, would that petechia still be evident or apparent?
Possibly, depending on the relationship of when they formed and when you died.
That's also maybe the manner in which death occurred. Would that have an effect or not?
Well, I think certainly at your age, if you were found and had petechia in your eyes, we would take that as a concerning finding. Unless we had information, but at your age, we ended up at our office.
Well, I think that's a compliment, Doc, so I'm going to take that.
Unless you had some other compelling disease process.
We're just going to log it as a compliment. May I first, Dr. Young?
Yes.
Let me show you what I just previously marked. Where it's been marked as Defense Exhibit number 5 and Defense Exhibit number 6. Do you recognize these documents?
This would be the original, Defendant's Exhibit 5 would be the original death certificate of Mary Sue Brooks. And 6 would be the facts of death verification, which would be another part of the death certificate.
So
This would probably be filled in by funeral home.
okay, so would these be together?
Yes, originally when you get a death certificate, it was all together. Now it's all electronic. So there's different areas that we fill in and different areas that the funeral home fills in.
So what's the difference between medical abstract of death certificate and the facts of death verification?
Yeah, so the medical abstract would be what the medical examiner fills in. The facts of death verification, that would be things of where, in this case, where the body was cremated, who the next of kin would be, where she died, that information.
Okay. And on Defense Exhibit 5, which is the medical medical abstract of death certificate. Under the cause of death, what is listed there?
Yeah, it says cardiovascular event / sudden death due to hypertension.
And I'm gonna stop you, Mr. Warren.
Yes,
You
ma'am.
already have an exhibit 5, so this would actually be exhibit 7.
Okay.
It's exhibit 7.
Sorry, thank you, Your Honor. So, Doctor, we're talking about defense exhibit number 7.
Okay, yes.
And Judge, just as proper predicate, if he could either offer the exhibit or so that we're not just reading from a document that's not evidence.
Okay, so your objection is?
Improper predicate, improper impeachment for whatever he's doing. I'm not sure what he's doing. Improper predicate.
I'll offer defense exhibit 6 and 7, Your Honor. Tentative statement.
I have no objection.
Thank you.
So, defense exhibit 6 and 7 are admitted.
Commissioner Bowles, Your Honor.
You have it.
Thank you, Judge. Hey, Doctor, so what we're talking about, defense exhibit 7, and at the top it says medical abstract of death certificate dealing with Mary Sue Brooks, is that correct?
Yes, sir.
And then has the date of death as what?
January 31st, 2018.
And then under the cause of death, there's 2 things listed under A and B. A says what?
Cardiovascular event / sudden death due to hypertension.
And it says approximate interval onset to death.
It says that, meaning the death was immediate and the hypertension was chronic.
And so explain both of those to the jury for me, Doctor, please.
Which part?
Both of them. So the cardiovascular event, sudden death, and that's immediate.
Okay. Well, okay. So in the part where it talks about cardiovascular event, what the person who signed the death certificate, her treating physician, based on his records, that she died from heart death, something cardiovascular, which is your heart, that it was a sudden death. And so then they're saying approximate interval, well, that's immediate, meaning that when you die, obviously death is immediate. And that it was due to hypertension, and that was an ongoing chronic disease process.
Thank you, Doctor. And since this was since there was no autopsy done on Ms. Brooks, this medical abstract of death certificate was based on information that was received from the officers at the scene. Is that correct?
You're talking about the death certificate, which we did not sign originally.
Correct.
Okay. I'm sorry. Would you restate your question?
But this information that's on defense exhibit number 2, the medical abstract of death certificate, that information was originally filled out, and this information that's on here is based on the information received from the officers and the people that actually responded to the scene where Ms. Brooks was found. Is that correct?
Well, the determination of the cause of death was made by the doctor who's her treating doctor. All the other information about timing, that would have been from the investigators, yes.
And then based on the information that you all received, your original cause of death was what for Ms. Brooks?
Well, we didn't rule an original cause of death. We determined based on what was presented to us at the time that it was a natural death, and we delegated the death certification back to her treating doctor.
And so is that when the in absentia report comes into play?
The in absentia is a report then that I generated, and we converted it to an in absentia, meaning that now, with further information, I'm changing the ruling and I'm taking over in my role as the medical examiner the authority I have to rule on the cause and manner of death. So that would have been generated later.
And on the in absentia report, which is State's Exhibit 293, here in the middle, it says originally, although the residents and the condition of the decedent were carefully examined by multiple law enforcement personnel, no significant investigative findings were identified. Accordingly, the death was believed to be a natural one, and certification was delegated to the decedent's personal physician, which is information that you stated would have been, they would have filled out on the death certificate.
Yes, sir, that's correct.
And you also, and as Mr. Fitzmartin had asked you earlier, you had seen the body camera, you'd looked at some photos from the scene, is that correct, or just
Yes,
the
sir.
body cam?
I saw the body cam and I have seen photos from the scene.
Okay. Did you also get an opportunity, Dr. Bernard, to view the body cam of Officer Harris, who was one of the first responding officers for Ms. Brooks?
I'm not sure which body cam it was. I think it was Harris's body cam.
Let me see if I
I mean, I don't know how many there were, but I think it was the original investigating officer.
Okay. Let me see if I can refresh your memory regarding that. It was the one where, on his own volition, he went back to take another look at Ms. Harris, or excuse me, Ms. Brooks. Do you recall that?
And move the body?
Yes, sir.
Yes, sir, that's what I saw.
And have you ever dealt with Officer Harris before?
No.
Okay. Did you, you understand that he's a very experienced officer with some detective experience, as well as there were some other officers on the scene that also had were very experienced. Were you aware of that?
No.
Okay. But they were confident in their initial findings as well as assessment of the scene, and stating that they didn't see anything odd or peculiar regarding that home and that residence, which is also what you put in your absentia report. Is that right, Doctor?
Yes, sir, that's correct.
And so, and then under the findings on States 293, it's all of this information there. Under your findings, you have 1, 2, 3, 4, 5, and on page 2 of it, 6 and 7. All of these findings were either received from, I guess, orally from the police department and or their reports. Is that correct?
Investigative information, that's correct.
So nothing medically or scientifically changed in regards to Ms. Brooks. Is that right? The information that you had?
That's correct.
Because you honestly really didn't have it, right?
Her body was not examined in her office. It was only based on the investigative information as well as what I saw in the photographs, which I said looked to be some superficial things.
So but for the fact that there are allegations that she had some property missing, your findings, you would have stayed in agreement with the original death certificate, which Ms. Brooks would have passed away for natural causes, correct?
Well, but for the investigative information, I would not have been suspicious there was anything else, and it would have stayed as it was. But the investigative information was compelling to me.
Sure, and which goes back to my original question, which is the correlation between the items and the things that were alleged to have been taken or were missing from her home is which led you, which are included in the findings, is which led you to change your conclusion in regards to Ms. Brooks.
Well, that's part of it.
But nothing scientifically or medically changed, correct?
Correct.
Thank you, Doctor.
Doctor, I'm curious, how many trained police officers do you have, experienced trained police officers do you have doing autopsies there at the Dallas County Medical Examiner's office?
None.
How many years of experience do you have in the medical field in order to hold this position?
Well, including my fellowship, over 35.
Okay.
Or nearly 35.
And you weren't out there that night to look at Mrs. Brooks to see if there's any kind of subtle things that a trained medical professional like yourself could maybe see on her body to get that body to your office.
That's correct.
Now, the information that you see in State's number 6 and State's number 7, actually no trained medical professional, especially anybody of your stature or anybody that you would have employed at your office to look for these things, actually looked at Mrs. Brooks in order to come up with these findings here.
That's correct.
So they go and they say, we have an individual who's 87 years old, who's dead in her own home, and that night no one knows that anything's missing from her. No one has any suspicion whatsoever. Is she just treated as an unattended elderly person's death at the home?
That's correct. Based on what their report was and her medical history, she was considered an unattended natural death.
And she's released to the funeral home, and the funeral home contacts her doctor to just find out what's going on with her, and they've got to put something down on a death certificate. Is that right?
And generally, they'll be notified of the death and then know that we have delegated them to sign the death certificate.
And they know that she has hypertension because you may not know this, so it's okay. But she's taken, the evidence, the jury has already seen that she's keeping track of her blood pressure, and it's actually not bad. Okay, so 6 and 7, defense 6 and 7, this is not your report. You base it on the evidence that's collected by other trained police officers that are just like the trained police officers that went out to that scene that night.
My absentia report and my change of the death certificate is based on the additional information that was provided.
Now, have there been times when a law enforcement agency has brought to you a scenario that they believe a criminal activity has occurred, and you have disagreed with that based on your medical findings?
Yes, that's happening.
So when we're talking about the night of January 31st, and we have a cause of death of the date of death of January 31st, that is the date that she is found. Is that right?
Yes.
Okay. Now that you have more evidence and you can use that evidence that's given to you, you are not constrained by what's placed on the medical abstract death certificate. Is that right?
No, I have the authority to change the ruling if I believe it's incorrect, in particular with an unnatural. If it's a natural death and it's been delegated, I might not agree with the way they worded it, but it's a natural death. But in particular, if the manner of death is incorrect and is unnatural, that is within the medical examiner's responsibility to certify.
Could you have, if you wanted to, have exhumed Miss Brooks's body to look for any kind of signs consistent with what we saw in, say, Miss Harris?
Well, I believe she was cremated, so I would not have been able to.
Right, but if that had not, the first question is, could you have, if you, in your capacity, have exhumed a body?
Yes.
Now, if that body is cremated, like we were talking about with Miss Brooks, there's no possibility of doing that.
No.
When talking about this petechia, and the defense lawyer is asking you about working out and throwing up a whole bunch of weight and causing this type of signs on an individual's body, you made a statement that said, yeah, but not to this extent. What do you mean by that?
Well, I believe the question was based on just the formation of petechiae, and so you can get some fine petechiae based on gravitational. You can get some in the eyes, hypothetically, from weightlifting. Certainly, as I said, I have seen it in nausea and vomiting cases. But we're talking about not just the eyes, talking about the face, talking about the neck, you're talking about the chest. That's a very exaggerated amount of petechiae, and I have never heard of somebody lifting weights, increasing their pressure and getting them throughout that entire location, or even vomiting and getting them in that location.
Okay.
In my experience.
So, in your experience, and with this individual, Miss Harris, the amount of petechia that she is exhibiting on her body, that would be the event that she went through that caused that is a significant event.
Well, in my opinion, this being a suffocation, that is a significant event.
How long does it take for someone to die in this manner?
Well, it really kind of depends on how...
Judge, I'm going to object to speculation as well as relevance at this point.
Judge, it is relevant because I have to prove the intentional act that was done in this case, and so I think there's a layer here that he's going to testify to, that there's a layer of probably passing out, and then there's a layer of what it's going to take in order to actually kill someone. So yeah, I have to prove specific intent in this case, and I believe it is relevant, and I believe as a medical professional he is able to testify to that.
And just in response, and I also add 403 to that, this is obviously the prejudicial effect greatly outweighs the probative value. He does have to prove that it was smothering, but smothering does not go into the length of time. I mean, if he determined it to be smothering, then the jury has to make that determination.
So, I guess I'm kind of confused. So you say that you agree that they have to prove intent. So then your objection is to the fact that the follow-up question was the length of the time?
Yes, Your Honor.
I don't know how we parse that out. How you separating that out?
From when?
Yeah, when you're saying that you agree with that intent has to be, proven, but you object to the doctor being able to talk about the length of time it would take.
That's correct. I mean, I still stand on the relevance as well as 403. Your Honor.
And so, Mr. Fitzmartin, with your question, can you rephrase your question? Let's just start over from there.
Okay.
And then we'll see where that takes us.
When an individual is going through the hypothetical situation of a pillow being placed over their face, okay, what are the stages that happens to an individual like that leading up to the point in time where they are going to die?
Well, that's an event where the nose and the mouth, if we're talking about a pillow, the nose and the mouth are obstructed with enough pressure they can't breathe. There's going to be a struggle if they're awake, rather than somebody who's unconscious when you do that. So if they're awake, there's going to be a struggle, and depending on how well that seal is, as to how rapidly they would be unable to lose all their oxygen. So if somehow the pillow comes loose, some will they get a little bit of breath, so the struggle can be more prolonged. So what ends up happening is they end up losing their oxygenation, and then ultimately they become unconscious, and then they die.
How long does it take for someone to become unconscious?
Well, that can vary, but it's not dissimilar to drownings where people are trying to hold their breath if they can't breathe, and so that could be anywhere from a minute to 2 minutes. Maybe even some people can hold their breath even longer, but it's not instantaneous.
And then how long does it take them to actually succumb to that and die?
Well, there'd be a period in which they're unconscious, and then ultimately their heart would stop. And again, that's somewhat variable, and I wouldn't be able to say the exact time that somebody would be alive, but they wouldn't be instantly dead. And they would not be instantly unconscious.
And as we look at State's Exhibit number 203, you see that there's that smudge mark. This is lipstick. As there is, that smudge is not just a perfect area of a mouth, it moves around. Did that occur?
Judge, I'm going to object to the leading as well as the compound nature of this question, Judge.
It's the same.
In my hypothetical, do you see that their smudge mark is more than just the size of 2 lips?
Yes.
Okay. So now, taking that smudge mark in this that's larger than the size of 2 lips, could this occur in those moments as you're saying that someone is fighting and looking for air as this is being placed over their face?
Yes, it could.
I'll pass with this.
Judge, I'm sorry. Thank you, Your Honor. Doctor, you had stated earlier, I think I got kind of confused. You said something regarding the natural and versus the unnatural deaths that you can make an adjustment or a new determination. What were you saying there?
No, what I said was that if you have a case that is natural, and, well, in any case, if I've done an autopsy on someone and I've ruled it natural, but then there's other information that comes back, I can still amend that. If, however, someone else has certified a case, a death, and information indicates it's unnatural, that is, it's not a natural death, I am responsible for unnatural deaths being certified, not the treating doctor, if it's unnatural.
Okay.
Now, if it's natural and I look at their death certificate and go, well, I wouldn't have worded it that way, well, that's different. I wouldn't take that over just based on they didn't certify it the same way I would. Now, you change the manner of death to unnatural, that falls within the medical examiner's purview.
Gotcha. And Dr. Mr. Fitzmartin had asked you a few moments ago if during your analysis or examination of the body, you make a determination that differs from the investigators or law enforcement, that you made a different determination before. Is that correct?
Yes, there have been cases where they came in, they were convinced somebody had been murdered, and our findings did not support that.
And have you, in your experience, have there been few or many?
After 30-something years, I can't really tell you, but it certainly is not one and only once. There have been many times that we've had cases come into the office where the direction that the investigators thought was not the direction that we ended up going because we did not agree with them.
And many would be relative in regards to your length of training. We're not training, but your length of experience as well, correct?
That's true. I mean, we have a large number of cases in our office, and so, trying to put a number on how many times we've disagreed with the police, we certainly have. I can't give you a number.
But it's not a normal occurrence. You agree with that, correct?
Well, I mean, if the police come in and they say that someone's been shot and we find 6 gunshot wounds, well, we're in agreement with that. But for example, say a child abuse case, and they're convinced that a child died from abuse and we find no injuries whatsoever, well, then we're not going to call that a homicide unless we've got information that someone smothered somebody or something else occurred.
Right.
So there have been plenty of times that, and I just picked that out of one thing, the child abuse, but there have been plenty of times that police believe a certain direction and we don't agree.
Okay. Thank you, Doctor. Appreciate it.
None further, Judge.
Thank you. Will this be released?
Yes, Judge.
Yes, Your Honor.
All right, you may step down. Thank you. You may call your next witness.
Your Honor, ladies and gentlemen of the jury of the state of Texas, rest this case in chief.
All right, thank you. Ladies and gentlemen, we're going to go ahead and take our morning break for now. If you'll go back to the jury room, we'll probably call for you about 10:30. So we want to go ahead and take that morning break.
All right.
The case in chief. On behalf of Mr. Chemirmir, the defense is going to move for the defense is going to move for a directed verdict. There's absolutely no way that the state has made a prima facie case or even close to met a burden beyond a reasonable doubt regarding each and every element that's been presented in the state's indictment. And we're just going to ask for a directed verdict at this time.
At this time, that will be overruled. Is there anything further?
Not at this moment.
Okay, all right. So at this time, we'll go off the record. We'll allow a brief conversation.
circumstance, situation, speak on it or anything. You understand that as well? Okay. Any questions and or concerns about that? No. I believe it's over there now.
All right. So, other than Mr. Chemirmir possibly testifying, does the defense anticipate calling any other witnesses so that I can determine what our next steps will be as far as the charging conference and things of that nature?
No, we do not. We intend on resting on it.
Okay. Just trying to figure out what we're going to do with the jury. That's it.
Judge, may I put a couple things on the record?
Yes, please.
We would like to offer for all purposes, I think the full extraction is in there, but the extraction summary states it's over 295. We'd like to offer that in the evidence for all purposes.
No objection.
Okay, what numbers were those?
295.
Okay.
And just to be clear, I think that's just the breakdown of a PowerPoint the jury's already seen.
Yes.
Or
They've already seen the PowerPoint. This is just the paperwork for it.
And the PowerPoint was at 296?
PowerPoint is no 294.
294, okay.
So 295 is record only or all purposes?
All purposes.
Okay. There's no objection, all right.
And then, Judge, we'd also like at this point in time to offer State's Exhibits 314, 315, 316, and 317, the large boards, into evidence for all purposes.
All right, so State's Exhibits 314, 315, and 316 will come in for all purposes. They will be admitted for all purposes.
And 317, Judge.
And 317, I'm sorry.
Thank you.
For all purposes. You want to put something on the record on it? Did you want to put something on the record over here?
Oh, sure.
I'm sorry, Judge.
Oh, did you have something else?
No, Judge.
Yes, okay. Hold on.
We do have other items that we need to offer for record purposes. Would you like to do that at this time or to get the jury in now?
We can do that after, because that's just for record purposes
Yes.
for our property
Yes.
issues. But I wanted to see the lawyers over here on the side. Justin, you got your phone? One more.
I'm not on the record.
Oh, that's fine. I'll do it.
Okay, I'm ready.
Crystal, can you hear it now?
Yes, Your Honor.
Okay.
all I had. I'll come over my defense and do it. Right here, all I have is in my defense. It was alleged that I don't think that's actually. But just in case I did, I apologize.
All right.
May all be seated. Okay, prior to our break, the state of Texas has rested and closed their case. What say you, defense?
Your Honor, ladies and gentlemen of the jury, at this time, defense will rest on behalf of Mr. Chemirmir.
We'll close.
Defense also closed, Your Honor.
Okay. Well, ladies and gentlemen, you have heard all of the evidence and testimony that you will hear in this case. So we will now take a court recess because I need to now get the jury charge ready for you so that you'll be ready to do your deliberations after we have closing arguments. But it is a necessity that we go ahead and get that jury charge together, which is all the instructions that you will have in order to do your jury deliberations. So we'll go ahead and we will retire you back to the jury room, and we will stay in communication with you by the bailiff that has you in charge, and we'll let you know when it's time to come in to do those closing arguments. Thank you.
All right.
And you can all be seated. Okay, so do we have a sample charge?
Judge, I believe we have the charge from the last trial, and that includes all the defense language that they have requested to be included. I think the parties are in agreement to use that charge again, but at this point, the state would be objecting to the inclusion of theft as a lesser. In the last trial, his confession came in which he stated in his confession that he buys and sells jewelry and that he had bought the jewelry on the side of the road, and it occurred to him maybe at the time that it could have been stolen. There is no evidence of that sort of any kind in front of this jury. And so in order for them to get a lesser, this has to be a reasonable alternative to the charged offense. There has to be some evidence that would support that. And we don't have any evidence that he merely stole the jewelry but didn't kill our victim. So same as with the murder and the ag rob, there's just no evidence of that. And so that would be the state's position, and we would ask that. That's on page 7 of the charge, that lesser included of theft be taken out. But other than that, we would have no objections to the charge at that point.
Defense?
Judge, I think we think that that should be left in just like it was last time. The state spent 3.5 days pointing out the fact that Mr. Chemirmir had possession of property and pointing out where his phone was, but I've yet to hear any shred of evidence that he was inside any of the houses or that he physically is the one who committed the action that led to any of the deaths. If the jury concludes that he did indeed have somebody's property, but there's nothing to base on the fact that he's the one who took their life or caused their life to be lost, then a rational jury could find that charge. As a matter of fact, would be bound to. So I think that that's one of the things they should be able to consider in their entire deliberations.
All right, thank you. So there has been no evidence of theft presented before this jury. No evidence of theft presented before this jury. I understand that you just now said that receipt of possible stolen property, the court doesn't recall any information or testimony regarding that as well. However, if there is some alternate language that you would like to present in regards to receipt of stolen property, the court will entertain it. But as far as the inclusion of theft in the court's charge, there has been no evidence or testimony to that.
Well, obviously, I would think the opposite of that. I don't think there's any evidence, since his statement come in, that he received or concealed any stolen property. He didn't say he got it from anybody. But what the state has at least attempted to prove is that he had other people's property. And if you have other people's property and that person didn't give you permission, then that's theft at a minimum. And based on the fact that there's amounts that come with all the property, I think you can easily get a state jail charge, and a rational juror could conclude that. The fact that they had that property, a juror may say, well, we know he had the stolen property, or maybe he took the property, we just don't know what happened, how he got it. And for a juror not to be able to consider that would deprive Mr. Chemirmir of a fair trial, of all the protections through the state and federal constitutions.
I'll take it under advisement, but specifically the portion of the charge, the portion of the theft area of the charge where it says, did then and there unlawfully appropriate stolen property, to wit, a red jewelry box and jewelry of the value of $750 to $2,500, said property having been stolen from the complaining witness. So, how do you make your leap?
What leap?
How do you get us to theft from the way it's written right now in the charge?
I don't have the charge.
It's just
Appropriate, I mean, the definition of appropriate is right there. It means to acquire or otherwise exercise control over property. And if it's unlawful, if it's without the owner's consent. If he's got property that doesn't belong to him, then he either stole it or received it. If a jury believes, which is what the evidence has been for 3 days, that he had other people's property, but they don't believe that he took their life or caused their life to be lost, that's a theft. And there's honestly been no evidence that he did that. It's all circumstantial that he's the one who even went into the location. I understand certainly why the state's making the case, but a rational juror could consider that he didn't go into those houses. And if he didn't, yet still had stolen property, that's a theft. Under the way appropriate is defined and the way theft is defined.
Thank you. State, you have a response?
I would just add that in order to be entitled to the lesser, there has to be evidence that he's guilty only of the lesser. So in the scenario that Mr. Hayes is describing, they believe he went in and stole the property or appropriated the property. There's just no evidence that he went there, stole the property, but didn't kill Ms. Harris. There's no evidence of that in front of the jury. Whereas before, there was evidence of that by his statement.
And that's just not what's required. The state still has burden of proof on every element. And if the jury doesn't believe that they met the burden of proof on homicide, the only thing left is a death, because they can still believe that. I'm not saying they will, and I'm not saying they should. I'm simply saying that they should be entitled to consider it. And by the court not putting it in there, that removes your ability to consider everything they should do.
One more thing I wasn't actually quite done. There's also no evidence of his knowledge that the property was stolen. So there's also that distinction as well.
Under their scenario.
Under their scenario.
And the last thing, just to point out something Mr. Warren indicated to me, and it's true, half the witnesses they called said that the individuals would have never given away their property and never sold the property. So if Mr. Chemirmir has it, they put on evidence that it must have been taken. A jury's just allowed to consider that he took it. It's especially based on some of the time frames of these situations, 2 and 3 hours. A lot can happen in 2 or 3 hour time frame.
All right. Well, other than the theft portion, have y'all had the opportunity to review the charge? I mean, I'll give you more time to look at it. I just want to make sure, one, that the defense has copies of the proposed charge. And I will give you time to review that. And then we'll come back and discuss if there's anything further other than the issue with the theft.
And I would point out also, they had requested lessers last time of murder, aggravated robbery, is that right?
And
objections to the inclusion of those. So those are not included in the, the final charge before it's back to the jury. So
I mean, since they brought it up, they'll be able to ask for all those. And then if they want to, the court can rule, have the court wants to rule.
And I think last time, Judge, we objected to all of that, and the only reason why you left the theft in was because of the statement that was made.
Yes, I recall. Well, there has been no information or evidence in regards to the inclusion of an aggravated assault charge or a burglary of a habitation, and I don't recall there was or the lesser of the murder. So I will not, or should I say, I will overrule the inclusion of adding aggravated assault, burglary, or murder based on the evidence that we have heard in this trial.
Can I point out one more thing, Judge?
Yes.
The law doesn't require that we put on evidence of something if it can be inferred from evidence that the state's already put on. And all those things can be inferred depending on what parts of the state's evidence you believe. We're not under an obligation to put on evidence to get any of those lesser included.
That is correct. However, there has been no evidence, testimony, or information that the court has received in order to include the lessers that have been requested. I will, of course, like we did previously, I'll take all of it under advisement. I have no problem going back, looking at the law to see what can and cannot be included. Is there anything else?
I think so.
Okay. All right, so I will go back and I will review the defense's request to have aggravated assault, burglary of habitation, murder, and theft in the charge. Other than that, is there anything else y'all can think of?
Judge, can I just do one housekeeping matter for Crystal? We were trying to just make sure that we know which exhibits are for record only. That way, when it's time to send it back, we have it kind of separated out. And so I've been keeping notes during the trial. I know you have as well, so I just kind of wanted to see if we were on the same page about that. So for record only, I have states exhibits 60, 207, 225, 226, 240, 281, 282, 284, 287, 288, 292, 301, 302 through 307, 308, and then 310 through 311. And then at this time, we'd also like to offer exhibits 259 through 265 and 268 through 276 for record purposes only. And those are these exhibits that we did not use in this trial, but we'd like to offer them for the record so they can stay with the trial record and all the other exhibits. Does the defense have any objections?
Is there any objection to states exhibits 256 through 265, as well as 268 through 276 for record only? It is all the items that were not entered into evidence before the jury. It's like the packaging and things of that nature that came from the police department.
I don't think so, but just for record purposes.
Yes, just for record purposes. When I go back to the jury.
And Judge, it was 259.
I had 256, I'm sorry, 259.
259 through 265.
259 through 265 for record only. No objection from the defense?
No, Your Honor.
All right. And in regards to the defense's evidence, I have two items that are for record purposes only. That should be item number 5, defense exhibit number 5, which was the disc containing the bite mark article from August of 2009. And then I have a defense exhibit number 8, which is a article that was presented to the court in regards to an article involving this trial. Are those the two items that we have listed as record only? Yes, sir.
Judge, on the defense exhibit number 5,
Yes.
that was an article. It was a National Academy of Sciences publication that basically undid the FBI protocol for hair follicle analysis analysis. Specifically, I don't think it mentioned bite mark. It might have
Oh, I'm
mentioned
sorry.
bite mark in passing, but it was August 2009 National Academy of Sciences publication on the undoing and the proper undoing of
The hair
follicle. Yes,
Okay,
ma'am.
thank you. Thank you for that clarification. So, defense exhibit number 5 was the article containing information about the, as we used the other day, the debunking of the hair follicle test, and that was from the National Academy of Science. And then we have defense exhibit number 8, which was an article from the news regarding this trial. Are those the 2 items that you had for record only?
For record only, yes, Judge.
All right. Okay. Want to make sure. All right, Crystal, we good?
Yes, Honor.
All right. So we will be in recess so that y'all can, if you have alternate language that you would like the court to consider, this would be the time to do that. So that once we all come back together, we can have all those discussions and we can have the jury charge conference. All right, we're in recess.
The YWCA of Columbus wrapped up an afternoon of honoring amazing women in our community.
The select group made significant contributions to their families and workplaces across Central Ohio. Some of the women honored today include Joy Bivens, Joanna Pickerington, and Laura Espy Bell.
Both my parents stressed the importance of using my voice for good, standing up for what I believe in, and the kindness does matter.
Espy Bell works as an emergency medicine doctor who strives to eliminate racial disparities in health care. You can find a full list of the honorees by looking for this story right now on our website at 10tv.com.
YWCA of Columbus wrapped up an afternoon of honoring amazing
I would ask that if all persons do not have copies of the jury charge, I would ask that the jury charge be provided to all parties. Once I am in receipt of that, we'll make sure that it gets stamped up so that it becomes the official court charge, and we will proceed